Forms of governance used by Canada's Indigenous peoples prior to European contact. Prior to European settlements, Indigenous communities of Canada were already constructed in different government structures. The Indigenous peoples' forms of government are considered independent or sovereign because each distinct group has their own independent culture, language, spiritual beliefs, economy, and law. And the knowledge, ability, and wisdom to govern their people are believed to be a gift from the Creator. Usually, indigenous groups living in the same region share similar cultures and government structure. For instance, the First Nations located across the 6 geographical regions of Canada. They have indistinguishable culture and tradition because of the environment and resources around that makes them have a common goal. Despite the similarities they have, indigenous groups still differ in terms of governing their people. According to the justice system and Aboriginal people, laws in an Aboriginal community was found in unwritten conventions even before the arrival of Europeans. Although the rules were never codified, they observed that there were consistent patterns in the treatment of such matters as relations with other nations, family problems, and disputes about behavior and property. And aside from oral tradition of passing history, stories, lessons, and knowledge from one generation to the next, certain evidences are also collected, just like the rock paintings or petroglyphs at Whiteshell, Manitoba. The indigenous government is very distinct and typically passed and interpreted in indigenous ways and language. To continue exploring the forms of government before the European settlement, this presentation will cover the indigenous laws and punishment for crimes that are based on indigenous morals and principles, and also the current Canadian justice system. Indigenous law refers to indigenous people's own legal systems. This includes the laws and legal processes developed by indigenous peoples to govern their relationships, manage their lands and waters, and resolve conflicts within and across legal systems. Prior to European contact, leadership within indigenous groups are vital for the communities. The leaders of the group are presently called chiefs, after the Europeans translated it into anglicized version for the mainstream society. The chiefs, or the leaders of the group, are defined differently in particular groups or nations. For example, the Sachem or Sagamore for Haudenosaunee. Sachem means the head or representative elected by the tribe or a group of bands, while Sagamore is lower ranked than the Sachem because it is elected by only a single band. Another example is the Nuchanult Hawi, which means hereditary chiefs. The Hawi Council is comprised of chiefs that govern 7 houses. Despite the different descriptions of indigenous leaders, leaders have common duties to the group, which is to respond to the needs of the people through hunting, gathering and shelter, leading the traditional and spiritual ceremonies, protecting the community, and maintaining the laws. Aside from chiefs, elders also play an important role in the governance of indigenous peoples. Elders in the community can be storytellers, teachers, healers, advisors, and protectors. Often, indigenous chiefs and other leaders of the group seek guidance from the elders to further improve and be knowledgeable of governing their community. Moreover, elders have a huge responsibility of maintaining the history, tradition, and beliefs in the indigenous community until to this day. If there's implementation of laws, social control should also be applied. In Indigenous community, social control rested in kinship. Among native cultures, the means of control was in the close contacts of their members. The sanctions of ridicule, avoidance, and shame were effective means to check those deviants who fell into behavioral lapses. These types of sanctions are appropriate to most misbehaviors within a small group, who are mostly composed of family members or kinship. It also includes extended families that are sometimes not related by blood. However, some misbehaviors require more serious sanctions than mere scolding or ridicule, which is equivalent to the very serious crimes considered in the Indigenous society. Crimes and sanctions in Indigenous society. Treason. Treason was considered the betrayal of the family group or clan, and often required the death penalty. Betrayal in the Indigenous community is a serious offense because the group's survival depends on the individual's cooperation and conformity. The second one is the practice of witchcraft. The Indigenous peoples use plants to treat and heal their members with traditional ways. Since the plants came from the land given by the Creator, the source of medicine should be respected and be used in a good way. Therefore, the practice of witchcraft or the use of bad medicine to inflict injury upon another were also treated as a serious crime. Witchcraft was much more difficult activity to prove, and it was handled in a more delicate manner. Also, the person using witchcraft might have to pay some form of compensation. In worse and rare cases, if the offender refused to compensate the complainant, he or she might face a death penalty. The following laws did or do not apply to the law and justice system of all Indigenous people in Canada, but only an example of law and punishment of the Huron people before the European contact, settlement, and colonization. The Wendat. The Wendat, or also known the Huron Wendat, are an Iroquoian-speaking nation that have occupied the St. Lawrence Valley and estuary to the Great Lakes region. The Huron-Wendat people are mostly nomadic in nature, and the sharing of goods and housing among extended families is normal for them. However, there are sometimes conflicts between the possession of movable objects and the accusation of theft. The act of theft is then defined as the taking of goods forcibly from an individual or from inside the longhouse without permission. In theory, a person was entitled to carry off anything he found lying unattended. And in order to protect their valuables both from fire and thieves, the Huron either carried them around or hid them in caches dug into the soil beneath their houses. The Huron did not order a fine or penalty to a thief, nor did they permit the victim to reclaim the stolen objects without first inquiring how someone else had come to possess them, and the refusal to answer was constituted an admission of guilt. If the offender was proven guilty, the victim and his family were socially sanctioned to go to the thieves' longhouse or their traditional dwelling and take everything on which they could lay their hands. So, even if a person had only stolen a small amount, their relatives would still be bruised and despoiled because the robbery was still committed. The kin group are put under pressure of social control among their members because the actions of every member reflect the disciplinary actions that are being taken within the family or the group. Murder. Murder is the highest degree of crime one can conduct for both Indigenous and non-Indigenous communities. For Huron-Wendat communities, murder obligates the kinsmen or relatives of the deceased to seek revenge by clamoring for the slaying of the murderer or someone closely related. This obligation is particularly borne by the clansmen of the murdered person, such as their siblings. Depending on the degree of relationship between the murderer and the victim, the killing could ignite a long-running blood feud among clan groups, villages, tribes, or even confederacies. The indigenous way of settling conflicts. Generally, in indigenous communities, a tribal organization and confederacy could not survive if the internal blood feuds persist. So, to avoid brutal and destructive feuds within the society, the indigenous people settle case through a system of atonement by the offender to the victim or to its relatives. All the members of the offender's clan or family will contribute to the compensation, which would then be shared by all the members of the victim's family. Only if such payment were refused, the clan would be justified in resorting to violence or arms. The amount of compensation could vary. The compensation for a crime against a chief or an elder, for example, was greater than that paid to a person of lower rank. And the compensation for a crime committed against a woman was greater than that of a man. Since the penalty would be paid by the offender's clan collectively, rather than just the individual offender, repeat offenders could expect to receive less and less support from their clan for their misdeeds. In this way, the clan or family, through peer pressure, would regulate behavior within the clan while exerting influence throughout society. The laws within the Canada's Indigenous community are based on collective rights. Therefore, by making social control a collective responsibility, Aboriginal people were able to impose law and order without resorting to capital punishment or other harsh forms of sanction. The philosophy in Aboriginal society was for all parties to acknowledge the crime, allow for some process of atonement, and install a system of reparation or compensation in order to restore harmony to the community. Canadian law and justice system. In most forms of government law and justice system, the aim is to control the actions that are foreseen harmful to the society as a whole, to individuals, or to the wrongdoers themselves by interjection, enforcement, or apprehension to prevent and punish deviant behavior. The punishment of the deviant is a means of making that person conform and to protect other members of the society. In the Canadian law, justice systems are powered by the Department of Justice, who ensures the safety and protection of all Canadians while supporting the victims of the crimes. Also, they are working with other organizations in the community to reach every citizen of the country. On the other hand, the Aboriginal justice system is governing their community respectively. In Canadian justice system, the general term for the punishment of crimes is called sentencing. Sentencing is the punishment of a crime ordered by a trial court after conviction in a criminal procedure. The following are some kinds of penalties and sentences that may be applied to various crimes committed under the Canadian law. The first one is the conditional or absolute discharge. Conditional and absolute discharge is only given to the less serious offenses. They can be ordered by the court after the finding of guilt and no convictions will be registered. A conditional discharge adds specific conditions or rules to address the accused conduct that led to the offense. The accused must agree to the conditions for a specified period of time through a probation order and will be discharged when the conditions are met. While an absolute discharge don't have any conditions or probation order. Suspended sentence and probation. Probation is the period of supervision when the offender must behave well and not commit any more crimes to avoid being imprisoned. A suspended sentence is similar to conditional discharge, as it involves following conditions in a probation order for a period of 1 to 3 years. However, the difference between is in suspended sentence, it has a registered convictions or you will have a criminal record. Fine. Fine is the set amount of money that the offender pays to the court as a penalty for committing a criminal offense. A fine may be combined with other penalties such as imprisonment or probation. Failing to pay the fine may lead to a civil judgment against the accused. Imprisonment. It is the most serious sentence under the legal system because it restrains a person from their liberty. However, the offender has the chance to have jail sentence off their record by applying for a pardon in order. The level of imprisonment varies on the duration of sentence. For instance, if an offender is sent to jail for less than 2 years, they will go to provincial institutions, while the offenders with a jail sentence of 2 years or more will be at the federal penitentiary. Life sentence. A lifetime imprisonment ordered by the court. In Canada, murder is either first or second degree. Persons convicted of either degree of murder must be sentenced to imprisonment for life. First degree and second degree murder convictions required at least 25 years of sentence, while parole is granted to those who serve between 10 and 25 years as determined by the court. Lastly is restitution. Restitution is the money the court may order an offender to pay the victim for the money that the victim lost as a result of the offender's crime. Under the Canadian law, the court can order restitution as a separate or standalone order along with other sentence, as one of the conditions of conditional sentence, or as one of the conditions of probation. The primary key factor of the clash between the Indigenous people and the Europeans during the colonization is the difference in worldviews, particularly because the values of Indigenous peoples are dependent on their collective rights, meaning they are part of a group. Their rights and laws are solely made for the group's common good and certain goals, while the Europeans are defined by individual rights. Individual rights protect the rights of an individual to pursue self-interest to live a fair life. According to the justice system in Aboriginal people, the differences between the worldviews account for the differences in principles, purposes, and practices of legal and justice systems. Each worldview is the basis for the customs, manners, and behaviors that are considered culturally appropriate. One's individual or cultural understanding of humanity's place in creation and the appropriate behavior that understanding dictates, pervade, and shape all aspects of life. To Indigenous society, the justice system is a means of restoring peace and harmony within the community, and to help reconcile accused with their conscience and the individual or family who suffered from mistreatment. But because the European and Indigenous justice system serve different purposes, the present law and justice system for Aboriginal people significantly challenges the appropriateness for dispute resolution, reconciliation, and the maintenance of communal harmony and good order. Laws grow from the customs, traditions, and rules of a society of people. They exist to inform people what that particular society considers to be acceptable and unacceptable. Despite the differences between Indigenous and non-Indigenous forms of governance, it always hopes to fruit the progress of the society by the implementation of laws. The diversity in culture and worldviews should have been respected since the Europeans settled in Canada to avoid the death of many Indigenous societies. A community cannot progress without a leader, as the society cannot live without a law.